Hello everyone, welcome back. In this video I'm going to talk to you about the Baker Act and the Voluntary Admission Agreement and whether or not the Baker Act facility can ask you to sign the Voluntary Admission Agreement before the 72 hours of the involuntary detention has even finished. In other words, that you've even been held for 72 hours. So just recall from some of the other videos, there's two types of Baker Act. Involuntary, that starts the 72-hour clock. There's also voluntary, which means potentially an indefinite hold without a court order, without due process, without any of that. Now, during COVID, people were going into facilities, not realizing what they were signing, agreeing to be voluntary. These days, for the most part, the time that we see a voluntary admission agreement is after the 72 hours has expired for an involuntary detention. 3 ways involuntary begins. Law enforcement takes you, qualified professional like an ER doctor takes you, or detains you, I should say, by the issuance of a professional certificate, or somebody files a petition in the court and a court orders you detained. Those are all 3 ways that the involuntary detention, the 72-hour clock, can begin. Now, at the end of 72 hours, one of 3 things is supposed to happen. They'll let you go. You agree to be voluntary by giving them consent to do so, and the consent has to be informed consent, meaning you understand the consequences of doing so, or they file a petition with the court for involuntary placement, meaning they want to keep you for a whole lot longer. Now, in this particular case that I got a call on, the person had literally been there for, I don't even think it was more than a couple of hours, and the facility was already saying, sign here, sign this, and he was reading it, and it said voluntary admission agreement, and at the bottom it said Baker Act. So he sort of got the idea that even if he was agreeing to be voluntarily, he was still Baker Acted, which he was. And so the issue was, well, why are they asking him to sign this now? Why don't they wait until the end of the 72-hour period to have him sign the voluntary admission agreement? And on top of that, they had also already told him they were planning to hold him at least 3 to 5 days. Now, based on my experience with that particular facility, I would say that the 5 days is more likely than the 3 days and potentially much longer. And what I said to him was, look, if they're already asking you to sign a voluntary admission agreement, what they're really telling you is they're planning on keeping you. I mean, they don't need, in order to keep you 5 days, all they have to do is at the end of 72 hours, file a petition for placement. That triggers a 5-day window, meaning that there has to be a hearing within 5 days. So a lot of the time what the facilities will do, knowing that they don't even plan to keep you, knowing they don't plan to try and go to court, is at the end of 72 hours, they'll file their petition because it automatically buys them up to another 5 days. So if they wanted to keep you even an extra 2 days beyond the 72 hours, all they needed to do was to file. Now, some facilities won't even do that. They'll just keep you because they know that you can't sue them for that, so they don't really care, and the doors are locked and you can't leave. So, well, too bad, right? So they'll just keep you. This facility, right out of the gate, wanted him to sign a voluntary admission agreement, even though he came in as involuntary. And what that tells me was that they're probably looking to try and keep him. They don't want to have a hearing. By the way, I don't even think he met criteria, not by a long shot. So they get him to sign a voluntary admission agreement. They don't even have to worry about the 72 hours. Now, I haven't seen that a lot, but it can happen. And so I guess the point that I'm trying to make here, and maybe it's a tad convoluted, sorry for that, is that whether you're detained on an involuntary basis or a voluntary basis, the bottom line here is you are Baker Acted. The state has taken custody of you, and your rights to make decisions for yourself, medical decisions, and the right to be free, those rights have been terminated. And so this is why I keep saying, I think in almost every video, that the time to fight is right now. He needs to fight to get out right now. I suspect they will try to keep him for as long as they possibly can. Oh, and by the way, he has great health insurance. There's a surprise, right? So they have a very good reason, and they're very highly motivated to want to keep him. And if they can get him to sign a voluntary admission agreement, they can hold him as long as they want. No court order needed, no hearing needed, no judge, no lawyers, nothing, none of that stuff. And I said, you got to fight to get out right now. So if and when we get hard on that case, I'll keep you in the loop. But, the facilities are always looking to try and get around, what little due process is built into the Baker Act. So I want to share that with you. And yeah, thanks for tuning in. See you in the next video. Bye-bye.